Welcome to Rochester Law Center, and thank you for being with us. Today, we're going to be talking about the pros and cons of a living will in Michigan. According to the Center for Disease Control and Prevention, 2/3 of Americans have no form of end-of-life healthcare preparation planned if they suddenly become incapacitated due to an accident, illness, or old age. Imagine if you became incapacitated and your loved ones had no instructions on your final wishes. They just had to guess. Unfortunately, if you're unable to communicate and you don't have a living will in Michigan, the burden of making your medical and end-of-life decisions may be placed on the shoulders of your loved ones with absolutely no guidance or instructions on what you would have wanted. This can be incredibly difficult and stressful, but the scenario is easily avoidable. By preparing a Michigan living will and pairing it with a medical power of attorney, you make your medical wishes clear and legally empower someone you trust to make the proper medical decisions on your behalf should the need arise. A living will, sometimes called an Advance Directive, is a legal document that allows a person to define end-of-life medical decisions in the event that they are incapacitated and unable to communicate or make judgments. A living will is different from your last will and testament. Think of your living will as a formal letter to your loved ones listing your final medical wishes, instructing them as to how you should be taken care of. Your Michigan living will outlines the types of medical treatment you would or would not want in certain situations. The assertions made in a living will include whether you would like CPR, artificial nutrition and hydration, maximum pain relief, artificial respiration, or if you would like to donate organs. If a living will is not prepared, several scenarios could occur. Doctors are legally obligated to perform certain measures to try to preserve a person's life, even in unfavorable circumstances. These actions could go against your intentions if they're not clarified in your living will. Furthermore, a spouse, child, or family member may be called upon to make decisions regarding life-prolonging means on your behalf. Being in a situation that necessitates these kinds of choices is trying, and placing these kinds of decisions on the shoulders of a loved one with no guidance can be very difficult for them. In the event that there are no living relatives, a court can appoint a guardian to make these choices for you and what they believe to be in your best interest. To avoid this, make a living will and let your relatives know where they can find it. Deciding and documenting your end-of-life wishes with a living will is beneficial for you and your family. It ensures medical treatment and end-of-life wishes are dictated by you, and it takes the pressure off of your loved ones so they don't have to make these difficult choices on their own without your input. It also makes sure that these decisions aren't placed in the hands of random family members, doctors, or the courts who don't know or understand your wishes. A living will does have some limitations. While it outlines and communicates your end-of-life decisions, it does not name a trusted person to direct your health care and execute the wishes in your living will if you're incapacitated and unable to do it yourself. In order to legally appoint someone to execute your wishes, it's best to have a medical power of attorney and financial power of attorney made to supplement your living will. Most people name a spouse, partner, relative, or close friend to act as their medical power of attorney. A living will plans for complicated end-of-life decisions. For this reason, it's usually best to consult with an experienced will attorney to ensure that your living will is written accurately based on your wishes and that it's legally binding. If you'd like to draft a living will, we can help you. Over the past decade, we've helped thousands of clients with all matters of wills, living trusts, and estate plans. To set up a free initial consultation, just give us a call at 248-613-0007 today. We offer phone and web consultations in addition to traditional in-office meetings. Let our staff know that you'd prefer to meet with one of our attorneys in the comfort of your own home via phone or web conference, and we'll get you scheduled based on your preference. Call us today at 248 613 0007. Again, that number is 248 613 0007. Thanks for joining us today, and we hope to hear from you soon.